Let us talk about the second very, very important act of German labor law, Protection Against Unfair Dismissal Act. The jurisprudence of Germany distinguishes between three kinds of termination, between three kinds of dismissal. First of all, extraordinary dismissal, dismissal on grounds of conduct. Secondly, ordinary dismissal, dismissal on grounds of ill health. And last but not least, dismissal due to operational reasons. Let us start with a dismissal on grounds of conduct. It is helpful to consider the law in this area under two separate headings. You can say you have to distinguish between an extraordinary termination and an ordinary termination. Dismissals on grounds of gross misconduct, extraordinary termination without any period of notice. Allow me to come to the prerequisites of such an extraordinary dismissal. First of all, there must be a fundamental breach of a duty of the employment contract. For example, fraud, a theft, or physical violence. Physical violence, of course, is a fundamental breach of duties for the employees of contracts. Last but not least, in this context, you must be aware of the fact that the right to dismissal for cause is lost if it is not exercised within 2 weeks after obtaining knowledge of the facts relevant to the dismissal. Let's continue to the dismissals for ordinary misconduct. Essentially, for an ordinary termination is that there are 1, 2, or sometimes 3 warnings necessary. Remember, what is the difference between the extraordinary termination and the ordinary termination? Essentially, for the extraordinary termination is that you need no warning. In contrast to the ordinary termination, you need normally 1, 2, or 3 warnings. A warning is the pre-stage of a dismissal. An effective warning notice must contain the following prerequisites. Reprimand citing the specific conduct in violation of a contract. This means you must explain the misconduct in a very detailed way. Secondly, demand that the employee cease such conduct. Statement that in the event of a repeated violation, the employee faces termination of his employment. These are the components of a warning. Dismissal on the grounds of redundancy, dismissal due to operational reasons. The grounds for this kind of dismissal are based on an entrepreneurial decision of the employer. In addition to this, you have to distinguish between external causes and internal causes. The employer, this is very important, carries the burden of proof concerning to the causes and their direct effect on the job in detail. External causes could be a drop in orders, a drop in sales, lower demand for products or services. Internal causes could be introduction of new work or production methods, to shut down a plant, for example, relocation of operations, outsourcing. In every case, jobs will be eliminated. The employer must present a plausible conception demonstrating that and how the corresponding work area can be operated permanently in the future with a reduced number of personnel. The labor courts may only review an entrepreneurial decision of the employer to ascertain whether it is prima facie unobjective, unreasonable, or arbitrary. This does not alter the fact that the employer must describe in detail how the implementation of its decision will impact the workplace in the long run and what the underlying operational concept is. Possibility of reassignment. The employee's jobs may be redundant, but it may be possible that he can continue to work for the employer. It is a duty to search, but the search must be a serious one. The employer has to attempt to find for the employee an alternative employment which belongs to the employer's group of companies. A dismissal for operational reasons is not an option if the employee can be reassigned to another free position within the company. If the dismissed employee can be reassigned to a free position, a dismissal for operational reasons is prohibited. The employer's obligation to retain the employee means that it must be prepared to offer reasonable further education or retaining possibilities. The employer must give the employee time to learn his new job, typically up to 6 months. Last but not least, let us talk about a very, very important prerequisite of the dismissal due to operation reasons, so-called social selection. If a job has been eliminated and there is no way the employee can be reassigned, the employer must carry out a selection, so-called social selection, soziale Auswahl. The social selection has the purpose to determine who can be released. A selection has to be made from those within the pool. The social selection must be carried out typically in 3 stages. First stage. The social selection must be carried out among all comparable employees within the entire works. Employees who have not completed the 6-month waiting period until the Protection Against Unfair Dismissal Act becomes applicable do not participate in the social selections. They must be the first ones dismissed, since they do not yet enjoy statutory protection against dismissal, so-called last in, first out. The decisive factor in ascertaining the comparability to ascertain which employees are comparable is whether they are interchangeable. Employees are interchangeable if they can take over each other's job immediately or after a reasonable training period. This is very important. Allow me to repeat. The most important point in this first stage of a social selection is to ascertain which employees are comparable. An employee is comparable with another employee if the employees are interchangeable. If they can take over each other's job immediately or after a reasonable training period, maximum 6 months. This is based on an objective as well as subjective considerations. The objective considerations include the job category, the skill job, the classification of the work, and the pay scale. All these are components which symbolizes if employees are interchangeable or not. Subjective considerations include the individual's abilities and skills, willingness to work. Second stage. From the group of comparable employees, employees which are interchangeable, those with the least eligibility for social protection must be the first to be dismissed. What does this mean in practice? The problem is there are no strict rules to determine this in practice. Each employee are pigeonholed with a numerical score based on the following criteria. For every year of his age, length of service, the employee has a claim for 1 point, for example. For example, he is 50 years old, equals 50 points. For every child, he has a claim for 4 points, for example. For the time of his length of service, he has a claim for 2 points per year. If he is married, he has a claim for 8 points, for example. If he is not married, he has a claim for 4 points. This is a very mechanical scheme, but it is helpful to find out which of the employee have more social protection than other employees. However, what important is that an employer should consider the different possibilities and come to a reasonable conclusion in defining the unit of selection. Against each criteria, the employee receives a score. Some criteria which are perceived as more important than others may receive a weighing so that they count for more towards the pool. It is so-called a redundancy selection procedure. In addition to avoiding age discrimination, the employer must take care that no criteria is a discrimination one to any other ground. The need for social protection is based on the following criteria: seniority with a company, length of service, age, family circumstances, married or not married, children or no children. Seniority with a company is of a paramount importance. In companies with work council, it is advisable to set guidelines for selection in which the weighting of the social factors is agreed to by the Works Council for future dismissals on operation grounds. This means if you have a Works Council, of course, it must be your aim to find a mutual agreement regarding to all these scores, to all these guidelines for social selection with a Works Council. If you have no Works Council, you are free, of course. The third stage of a social selection. If individual employees have special qualifications, knowledge or skills, and if their retention is of particular importance to the company, such employees may be excluded from the social selection. Moreover, securing a balanced range of ages is one of the operational interests that would justify it in special cases from the social selection rules. Ladies and gentlemen, we will talk now about another kind of dismissal, so-called dismissal on the grounds of personal ill health. You have to be aware of the fact that the burden of proof is somewhat high for the employer, who must present clear and convincing evidence to sustain a dismissal based upon ill health. The reason is that it is so difficult for the employer to prove the prerequisites of a dismissal on the grounds of personal ill health. The following prerequisites must be met. First prerequisite, so-called negative prognosis. First of all, there must be an inference that the employee will continue to be absent due to illness in the future, so-called negative prognosis. In addition to this, the jurisprudence of Germany requires that the kind of illness of the employee must be chronic. Non-chronic illness in most cases would not be grounds to discharge an employee upon ill health. You have to distinguish between three kinds of groups. The first group is about employees who are ill for a duration of 2 years and more. Under these circumstances, the jurisprudence of Germany states that because of the reason of such a great duration due to illness, there must be a negative prognosis. The second group is about employees who are ill for a duration of 8 or 10 months. In this case, the employer has the burden of proof to present clear and convincing evidence that the employee will be sick for the next 24 months in addition. Normally, it is so difficult to present evidences in such a case. The consequence is that the employer has basically no chance to win such a dismissal at labor court because he is not able to present clear and convincing evidence that the employee will be sick for the next 24 months too. The third group is about employees would be those at regular intervals who claim to be sick. Instead of long periods of time, they routinely claim that they are sick a few days every week or a few days every month. In this case, you have to check a reference period of at least 3 years. For example, they must be ill in this period of time at least between 14 days till 60 days per year. In this case, it is necessary to study the history of the absenteeism of the employee. Last but not least, serious detriments to business interests. As the consequence of the illness of the employee, there must be serious detriments or prejudice to the company. Examples: loss of production, or loss of customers, or there was a removal of necessary employees from other areas. Disruption of business operation includes loss of production, excessive strain on the remaining personnel, removal of necessary employees from other areas. In addition to this, you have to check the weighing of interests, so-called balance of interests. In weighing the interests involved from the employer's point of view, predicted future adverse effects on the business, extend to the disruptions of business, financial condition of a company, security risks, must all be taken into account. From the employee's point of view, the factors to be considered are the duration of the employment relationship, length of service, the employee's seniority with a company without periods of illness, his age, number of dependents, and other factors entitling him to special protection.